That's it's very important for the community to know what's going on and how they're going about it, how legislation is going about putting this crime package together. But that's why we have a panel, and I'll hand it over to them.
Hi everyone, as you heard, my name is Tatum Pritchard. I'm a staff attorney with Prisoners Legal Services. Thank you very much for having me. It's a pleasure to be here in Worcester and to talk about this law. Because first and foremost, what we'd like to do is make sure that it doesn't pass. Unfortunately, right now, the two bills, there's a Senate version and a House version. They're in a conference committee comprised of 3 senators and 3 representatives. Those 6 legislators will determine the final form of the bill, and then that final bill will be sent to both houses for voting, yay or nay, whether or not those will pass. At this point, it seems as though the bill has a lot of momentum, and it is probably going to pass. So what we need to do is make sure, number one, that we voice our concerns, and that we do not want it to pass, and number 2, that we get the legislators to make this bill as narrow as possible. So what this bill does, as you heard, it's called the 3 strikes bill. That's one portion of the bill that we're talking about. It has to do with the habitual offender law in Massachusetts. Some of you may not know, but we already have a habitual offender law in Massachusetts. It's been on the books since the late 1800s. It just so happens that at this point in time, the prosecutors don't use it a whole lot. What these bills do is make that habitual offender law much more harsh. The one section of the bill, it's split into 2 sections. The first section pretty much mirrors the existing habitual offender law, applying to every felony, all 688 felonies in the Commonwealth, and counting convictions for those where you've received state prison time of 3 years or more as strikes. If you're convicted of a 3rd felony, then you're subject to the maximum sentence for that felony. And for those 688 felonies, you're permitted parole at 2/3 of the maximum sentence. Now, not to get too technical, there is the second, more dangerous portion of the bill, which is subsection B. This is brand new, and this is what they say is focused on violent habitual offenders. The sections are slightly different in the House bill and the Senate bill. The Senate bill, from our perspective and from the perspective of all of the opponents of the bill, is worse. So I'll discuss the Senate version just to give you an idea of what I mean by worse. The Senate bill takes 59 felonies and puts those on a list of crimes that will count as strikes towards your 3 strikes. If you're convicted of any of those 59 felonies 3 times, then you're sentenced to the maximum term of incarceration without the possibility of parole. So if you've committed a crime that happens to be a life felony, for instance on this list, an example of that is an armed robbery, you'll be sentenced, if that's your 3rd strike, to life without parole. Now under current law, the only way that you can be sentenced to life without parole is if you've committed 1st-degree murder. This bill changes that and allows for people committed of 22 different crimes to be convicted and sentenced to life without parole. So obviously that's great cause for concern, especially given the nature of some of those crimes that are included on the list. There are other crimes, of course, that don't carry a maximum of life. Some of the crimes carry a 5-year maximum in state prison. But when you're dealing with state prison, that's a long period of time as well. And when we say there's no eligibility for parole, that also means that there's no eligibility to participate in programming. You're not eligible for good time. So all of those things that you could possibly take advantage of while you're in prison, they're not available to you because there's no way to shorten your sentence, and the DOC won't allow you to participate and beneficial programs if it won't shorten your sentence and get you off of their hands. So I guess other things to mention in particular about the law, maybe the best thing you can say about it is it doesn't actually count juvenile adjudications of delinquency. So that's a good thing. But it does count a lot of crimes that, from the perspective of an attorney, of a former public defender, looking at the elements of those crimes, it includes a lot of crimes that shouldn't be included when you're talking about the worst of the worst, which is what this bill is supposed to be aimed at. Some of the crimes allow for conviction based on acts that basically consist of assault or assault and battery. Assault doesn't even require any physical contact at all. Assault and battery, there has to be some sort of unwanted touching, but there's no injury required at all. So, the seriousness of the offense is not clear from the elements of the crime. As it should be, these crimes should be sentenced by judges who can take into consideration the facts of the actual case, the background of the person, including their criminal history, but also including their substance abuse problems, their difficult family life, all of those things to come up with a reasonable sentence. Now, what the three strikes law does is remove from the judge any discretion to sentence people to anything other than the maximum. And it's our position at Prisoners Legal Services, and I think that's shared by most opponents of the law, that one-size-fits-all criminal justice policy is simply unsound. There's no good reason for it, and research does not show any link between longer prison sentences and reduced recidivism. So not only is this tough on crime, it's not smart on crime. This is not making our community safer. In fact, it's just warehousing people and making it more difficult for them when they get out from those long prison terms without having the opportunity to participate in programs or parole. They've also asked me to speak about mandatory post-release supervision, which is a provision that's in the Senate bill. Mandatory post-release supervision is essentially forced parole after you've wrapped your sentence. So after you've finished the sentence that the court has given you, after you've served your debt to society, mandatory post-release supervision, anywhere from 9 months to 2 years, is imposed upon you. And you have to be supervised by a parole officer during that period of time. The most disturbing part about it is that you can be violated, just like on regular parole, you can be violated for criminal or non-criminal behavior and put back into prison. This is especially dangerous because the time that you spend in prison for those violations does not count towards the time of your supervision. So there will be some people, for instance, individuals who just can't kick their drug habit, who get on the street after they've been in prison for many years, slip up, use drugs. They have a positive screen. Their parole officer puts them back in for the first time 2 months. They get back out, it happens again, and the cycle continues in such a way that someone could be serving those 2 years of mandatory post-release supervision for decades. So that's, from my perspective, that's the most dangerous part of that provision, and it shows a real lack of understanding of legislators about the realities of what people go through, especially after they've been serving a long stint in prison without the opportunity to benefit from programs and from, readjust to the real world, essentially. So I guess right now, I'll hand it over to Ben Thompson.
implementaiton. How's Worcester doing tonight? I wanted to first thank EPOCA for hosting this, this community forum. I'd also like to acknowledge two of my Boston colleagues that have came in, Cornell Mills and Jamal Crawford. They're in from Boston. These gentlemen have been doing a lot of work recently helping to organize forums such as this. We're going to be in Lowell tomorrow. We're going to be in Springfield on the 23rd. They're working on Lawrence and New Bedford. So these are real, like many of you, they're real community activists, and without them, you know, a lot just doesn't get done, as with the people here at EPOCA, and some of the people in the audience. So I just wanted to acknowledge that. I think I'm going to jump all over the place here, if you don't mind.
Not at all.
Thank you. Let me start with, I always believe that sometimes you learn by listening and telling stories, and I've been a storyteller for much of my life. But let me just give you a little bit of quick history. If you go back to the, and I'm going to lead you into what happened with this habitual offender bill, because history is important. But if you go back to the early 1990s, there was a horrific crime in California. A young female was murdered by an ex-offender. And that murder led to the creation of the first 3 strikes law in the country, which I think was passed around 1994. Now, interestingly enough, in California, people who are in the prison system in California, they're called strikers. If you're in for your 2nd strike, because the law mandates additional time on the 2nd strike. If you're in for your 3rd strike, in many cases it mandates life without parole, but they're called strikers. So interestingly enough, in 1994 and 1995, the first 3 strikes laws passed in California. So think about that. The first striker in California does not come up for parole until 2019. Think about that. That's 7 more years before the first striker comes up for parole in the state that initiated the first 3 strikes law. So this is something that if passed, it's going to be with us forever. And we just start counting now, but look at where we're at. 2019, the first striker comes up for parole. So that's something you should keep in your mind. Fast forward to Massachusetts about 10 years ago or so. We had a horrific killing. A young female was murdered, again, by an ex-offender. And from that came a group of people who came together and they tried to pass what became known as Melissa's Law. And we all acknowledge that it was a horrific crime. But for years, there was an effort made to sort of create this one-size-fits-all for ex-offenders who had been habitual offenders. And it really got no traction for 10 years until Sinelli murdered a police officer in Woburn. In which case, those same forces that had been working for 10 years to pass Melissa's Law sort of came together, and what you ended up with was the governor submitting a bill that was called the Habitual Offender Bill / Sentencing Reform. Now, one of the things that's interesting that I want you to also keep in the back of your mind is that one of the things that happened when this bill came up for a vote is that Mr. Gosel, the father of Melissa, was in the chambers, as was Mrs. McGuire, the wife of the slain police officer. They were in the chambers. There was a lot of passion, a lot of emotion that went into the passage of this bill. But all of that passion and all of that emotion was on one side. So I want you to just keep that in your mind. When we talk about, and one of the things that I've been saying recently is that the people who are organized to try and slow this down, change this bill, stop this bill, kill this bill, alter this bill, we believe that there were people of goodwill who made a bad decision. We don't believe that there were bad people necessarily in the House or in the Senate. We believe that what we saw with the passage of the Habitual Offender Bill was public policy developed and crafted on emotion, without listening to both sides and without having a cogent argument, so that when we make public policy that's going to be with us for years and years. Remember, the first striker doesn't come up for parole for 7 more years. So if you were born in 1994, think about your entire life, a striker hasn't come up for parole yet. So keep that in the back of your mind, because what we saw in the State House was public policy being developed on emotion. And that just doesn't work. We also had heard from people, especially in the legislature, who said, this is a cost-neutral bill, meaning it's not going to cost taxpayers any money, because we all know who pays for prisons. It's taxpayers. It's people who go to work every day. You pay for prisons. So you've got the legislature saying to you, we're going to pass this cost-neutral bill, and you say, well, how's it going to be cost-neutral? They say, well, we're going to pass a mandatory minimum provision that basically lets low-level people who are selling drugs out, and they don't have to serve a mandatory minimum sentence. So those are the people that are going out, and we'll offset it by the people we're going to bring in, who they tell you are going to be the worst of the worst. They're going to be these violent criminals who are ravaging the system. And that's going to offset it, so it's not going to really cost us any money. Now, if you go back to 1994, the same time that the first striker bill was passed in California, it's when the legislature here passed the Big Dig. Now think about this. They told us the Big Dig was going to cost $400 million. We topped out at, what, $14 billion? So whenever an elected official tells you it's not going to cost you anything, hold your pockets, because he's coming after your money. So just keep that in the back of your mind. So now we're in a position where we're looking at legislation that we believe was passed on emotion, and we believe that if you use evidence, because one of the things, I mean, this is 2012. If you just go to Google, and try this when you get home, if you've got a system, if you Google 3 strikes and put in the 3 strikes and prison cause, it'll draw up all of this research that's out there that will tell you that prisons expand under 3 strikes. 3 strikes is in 25 states now. In California, the first 3 strike state, the cost of prisons increased by 27% a year. So that from 1988 until today, the prison costs have increased 500%. Who pays for that? California tried to build their way out of it. They passed 3 strikes, and then the Supreme Court came in and said, you've got to release 30,000 to 40,000 inmates within 2 years early, because we've got no place to put them. And you created a cruel and inhumane system. So, my wife's laughing at me. So, keep that in the back of your mind, because I've heard the governor say, we're not California. Well, no, we're not.